Whenever it is charged that any person has engaged in an unfair labor practice within the meaning of subsection A3 or B2 of Section 8, such charge shall be given priority over all other cases except cases of like character in the office where it is filed, or to which it is referred, and cases given priority under subsection 1. Investigatory powers. Section 11. For the purpose of all hearings and investigations which, in the opinion of the Board, are necessary and proper for the exercise of the powers vested in it by Section 9 and Section 10. 1. The Board, or its duly authorized agents or agencies, shall at all reasonable times have access to, for the purpose of examination, and the right to copy any evidence of any person being investigated or proceeded against, that relates to any matter under investigation or in question. The Board, or any member thereof, shall, upon application of any party to such proceedings, forthwith issue to such party subpoenas requiring the attendance and testimony of witnesses, or the production of any evidence in such proceeding or investigation requested in such application. Within 5 days after the service of a subpoena on any person requiring the production of any evidence in his possession or under his control, such person may petition the Board to revoke, and the Board shall revoke, such subpoena, if in its opinion the evidence whose production is required does not relate to any matter under investigation, or any matter in question in such proceedings, or if in its opinion such subpoena does not describe with sufficient particularity the evidence whose production is required. Any member of the Board, or any agent or agency designated by the Board for such purposes, may administer oaths and affirmations, examine witnesses, and receive evidence. Such attendance of witnesses and the production of such evidence may be required from any place in the United States or any territory or possession thereof at any designated place of hearing. 2. In case on contumacy or refusal to obey a subpoena issued to any person, any United States District Court or the United States Courts of any territory or possession within the jurisdiction of which the inquiry is carried on, or within the jurisdiction of which said person guilty of contumacy or refusal to obey is found, or resides, or transacts business, upon application by the Board shall have jurisdiction to issue to such person an order requiring such person to appear before the Board, its member, agent, or agency, there to produce evidence, if so ordered, or there to give testimony touching the matter under investigation or in question, and any failure to obey such order of the court may be punished by said court as a contempt thereof. 3. Repealed. 4. Complaints, orders, and other process and papers of the Board, its member, agent, or agency may be served either personally, or by registered or certified mail, or by telegraph, or by leaving a copy thereof at the principal office or place of business of the person required to be served. The verified return by the individual so serving the same setting forth the manner of such service shall be proof of the same, and the return post office receipt or telegraph receipt therefore when registered or certified and mailed, or when telegraphed, as aforesaid shall be proof of service of the same. Witnesses summoned before the Board, its member, agent, or agency shall be paid the same fees and mileage that are paid witnesses in the courts of the United States, and witnesses whose depositions are taken, and the persons taking the same shall severally be entitled to the same fees as are paid for like services in the courts of the United States. 5. All process of any court to which application may be made under this Act may be served in the judicial district wherein the defendant or other person required to be served resides, or may be found. 6. The several departments and agencies of the government, when directed by the President, shall furnish the Board, upon its request, all records, papers, and information in their possession relating to any matter before the Board. Section 12. Any person who shall willfully resist, prevent, impede, or interfere with any member of the Board, or any of its agents or agencies in the performance of duties pursuant to this Act shall be punished by a fine of not more than $5,000, or by imprisonment for not more than 1 year, or both. Limitations. Section 13. Nothing in this Act, except as specifically provided for herein, shall be construed so as either to interfere with or impede or diminish in any way the right to strike or to affect the limitations or qualifications on that right. Section 14. Nothing herein shall prohibit any individual employed as a supervisor from becoming or remaining a member of a labor organization, but no employer subject to this act shall be compelled to deem individuals defined herein as supervisors as employees for the purpose of any law, either national or local, relating to collective bargaining. B. Nothing in this act shall be construed as authorizing the execution or application of agreements requiring membership in a labor organization as a condition of employment in any state or territory in which such execution or application is prohibited by state or territorial law. C. 1. The Board, in its discretion, may, by rule of decision, or by published rules adopted pursuant to the Administrative Procedure Act, decline to assert jurisdiction over any labor dispute involving any class or category of employers where, in the opinion of the Board, the effect of such labor dispute on commerce is not sufficiently substantial to warrant the exercise of its jurisdiction, provided that the Board shall not decline to assert jurisdiction over any labor dispute over which it would assert jurisdiction under the standards prevailing upon August 1, 1959. 2. Nothing in this act shall be deemed to prevent or bar any agency or the courts of any state or territory, including the Commonwealth of Puerto Rico, Guam, and the Virgin Islands, from assuming and asserting jurisdiction over labor disputes over which the Board declines, pursuant to paragraph 1 of this subsection, to assert jurisdiction. Section 15. Omitted. Reference to repealed provisions of bankruptcy statute. Section 16. If any provision of this act, or the application of such provision, to any person or circumstances, shall be held invalid, the remainder of this act, or the application of such provision to persons or circumstances other than those as to which it is held invalid, shall not be affected thereby. Section 17. This act may be cited as the National Labor Relations Act. Section 18. Omitted. Reference to former section 9, F, G, and H. Individuals with religious convictions. Section 19. Any employee who is a member of and adheres to established and traditional tenets or teachings of a bona fide religion, body, or sect which has historically held conscientious objections to joining or financially supporting labor organizations shall not be required to join or financially support any labor organization as a condition of employment, except that such employee may be required in a contract between such employee's employer and a labor organization in lieu of periodic dues and initiation fees, to pay sums equal to such dues and initiation fees to a non-religious, non-labor organization charitable fund exempt from taxation under Section 501c3 of Title 26 of the Internal Revenue Code, chosen by such employee from a list of at least 3 such funds designated in such contract, or if the contract fails to designate such funds, then to any such fund chosen by the employee. If such employee who holds conscientious objections pursuant to this section requests the labor organization to use the grievance arbitration procedure on the employee's behalf, the labor organization is authorized to charge the employee for the reasonable cost of using such procedure. Section added. Public Law 93-360, July 26, 1974. 88 Statute 397, and amended. Public Law 96-593, December 24, 1980. 94 Statute 3452.